I welcome you to this video. The title of this presentation is Introduction to Criminal Law. My name once again is Kehinde Adegbite. I welcome you to my YouTube channel, Kenny's School of Law. So in this video, I will concentrate mainly on the Nigerian law, but once in a while, make reference to the criminal laws of some other countries. So this is my outline. I want to make this video to be short. I don't want it to be too long. So it is most likely I will have the second part. But in this one, I will be talking about what is criminal law, examples of crimes, criminal law versus civil law. So learning objectives. At the end of this presentation, I expect that every viewer should be able to know definition of criminal law. What is a crime? Then finally understand differences between criminal law and civil law. What is criminal law once again? Now, it is a system of law that defines acts or omissions which constitute crimes and prescribes punishment for infraction. The primary objective of every system of criminal law is to specify what an offense is and what punishment is to be imposed. So from this definition, we see certain keywords like acts and omissions. So let's take them for act, for instance, for conduct, for behavior, which the law has classified as crimes if committed, or omissions if there are responsibilities, there are duties imposed on a person and the person has failed in discharging the responsibilities, then the person has omitted in discharging the responsibilities, and that omission is a crime in itself. So once the law says an act or a conduct or omission is a crime, then the issue of punishment will come in once that prohibited conduct is carried out. So we said the primary objective of every system of criminal law is to specify what an offense is. So the law has to specify, has to define, has to put it in writing what acts, what conduct, what behavior will amount to an offense and the punishment that is to be imposed if committed. Every country of the world has its criminal law system. So because we know that protection of life and property is paramount and universal, and again we know that there is no society that is perfect. We always have people who will do things that ought not to be done, especially acts that amount to criminal behavior. So, and in that regard, the law, there is usually a punishment which is meant to deter other people from committing the same prohibited acts, or even to also discourage those who have committed one now not to commit it another time, and again to ensure that people who commit, who have inflicted some wrongs on other or pain on other, they also have a feel of the pain which they have inflicted on others. So there are crimes that are regarded, there are crimes that are common all over the world, that wherever they are committed, whichever country they are committed, laws generally regard them as crimes. Like murder is a crime all over the world. The punishment may be different. In some countries they may have death penalty, in some other countries they may not have death penalty, they might have abolished death penalty, in which case there may be life imprisonment, there may be some number of years of imprisonment, and in some others, murder as a crime may carry death penalty. In Nigeria it carries death penalty. In the US, in UK, they don't usually encourage death penalty. In South Africa, they don't have death penalty. They have terms of imprisonment. Stealing is another crime that is common all over the world. There is hardly any country that does not criminalize stealing and murder. But There are also acts, behavior, omissions that, if committed in some other countries, they are not regarded as crimes. For instance, abortion is not a crime in many countries. In Canada, it is not a crime. In South Africa, abortion is not a crime because a woman, or yes, a woman, whoever is pregnant, has the prerogative to decide whatever to do with that pregnancy, whether to keep it to maturity or to terminate it. So, but in Nigeria, that is not the case. You don't have the restriction on abortion. Abortion can only be carried out in Nigeria if the life of a mother is in danger. So it can be carried out in order to save the life of the mother. But if there is no such justification, then under no circumstance should abortion be carried out. So whoever performs abortion on a pregnant woman, that person is guilty of a crime. Then a woman too who carries out abortion on herself, who aborts her own pregnancy, who does anything to abort it, can also be penalized. So, but then in Nigeria, people still carry out abortion, despite the fact that the law, it does not allow it, despite the fact that it's a crime if committed in Nigeria. People still carry out abortion. And in fact, maybe because it is criminalized in Nigeria, it also maybe pushes some people to still go into abortion, because there are circumstances when people may not want to keep their pregnancy. For instance, teenage pregnancy. A young lady, a teenager who is pregnant and is not ready to keep the pregnancy, may go into abortion, and at times they go into the patronized quack doctors, those who are not really qualified doctors, to perform abortion, which is usually unsafe on them because the law does not allow it. So they can't get it legally. They can't go to good hospitals to have abortion because medical personnel, they will not do it. They know it is against the law. And in some other cases, persons who get women who get pregnant, maybe as a result of rape or as a result of adultery, may also not want to keep the pregnancy. But abortion still takes place in Nigeria, despite the fact that it is a crime. That is the point. And again, same-sex marriage is a crime in Nigeria. It's not a crime in many other countries, especially in the Western world. In Canada, it is not a crime. In America, it is not a crime. It's now allowed. In South Africa as well, abortion, same-sex marriage can take place. But value systems also drive what each country defines as a crime under its criminal law. And again, what is a crime today in a country may decriminalized tomorrow. So take for instance, attempted suicide was a crime in India until 2018. Until 2018. In 2017, Mental Health Care Act was passed, and there is a section in that Mental Health Care Act which removed attempted suicide as a crime from the Indian penal code. So today, anybody who attempts to kill himself or herself will be referred to health facility, mental health facility, where the person will be treated, because it is seen as a mental health case, and not that anybody who attempts to kill herself or himself deserves to be punished, which is the case in Nigeria, that once somebody attempts to kill himself or herself and the person is caught, then the person will be prosecuted for having committed a crime under the criminal law. Though there are agitations that attempted suicide should be decriminalized even in Nigeria, and people who attempt it should rather be treated, because mental health practitioners and advocates see that as a mental health issue, not a criminal issue. So, and again, I must also say that what is not yet a crime today can become a crime tomorrow. Hate speech is an example. As we speak today, it is not defined. Hate speech is not defined in any law in Nigeria, which has been passed by the legislative authority. It is not yet a crime. Fake news is not yet a crime in Nigeria. So it is not specifically defined, especially fake news circulated through social media and some other online platform. So it is an act that people are also agitating that it should become a crime in the country. So criminal law changes from time to time, as we know that law is dynamic and societies too are dynamic. So let me move to another slide. So I continue with, then we said that criminal law is the system of laws that defines acts and omissions which will be penalized if committed. So what is a crime? It's in itself. What is a crime? This Black's Law Dictionary defines crime as an act that the law makes punishable, the breach of a legal duty treated as subject matter of a criminal proceeding. So there are, as I said before, there are acts that have been defined under a specific law to amount to a crime if committed. So for any act or omission to constitute a crime, it must be defined in a law. It must be called a specific crime, whether it is rape, whether it is murder, whether it is attempted suicide, whether it is attempted rape, whether it is arson, whether it is stealing, whether it is robbery or armed robbery, depending on the crime. So anything that is not called a crime, then it is not a crime. And if committed, nobody can be penalized for such acts. For instance, wearing dreadlocks, especially by males, is not a crime in Nigeria. So law enforcement agents cannot arrest anybody for doing that, because if anybody is arrested for doing that, then that will amount to violation of that person's rights. I continue with of the criminal law with crime. Now, the word offense, crime, criminal offense, they are used interchangeably. They all refer to crime. They all mean criminal act. In other words, crime can be defined as an act or omission which renders the person doing the act or making the omission liable to punishment under a written law. These quoted words are actually borrowed from the Criminal Code, Section 2 of Criminal Code. I will explain what is meant by Criminal Code either in this presentation or in part 2. It's simply a criminal law, so I will throw more light on it later. An act or omission which renders, there are keywords in this definition. Acts, as I said before, acts or omission, we have to pay attention to this. Then, which renders the person doing the act or making the omission liable to punishment. So there must be punishment. If there is no punishment prescribed, then we cannot say a crime has taken place under a written law. So it has to be in a written law. So these are three elements or three features of what amounts to a crime: an act or omission which renders the person doing the act or making the omission liable to punishment. So if a young person fails to greet an old man or old woman, unless it is defined in a written law that doing that is a crime and the punishment is so, then it is not a crime, even when an omission has taken place. When a young person has omitted to greet an elderly person, that is, there is no crime. But if a police officer stands while somebody is killing another person, a police officer, a law enforcement agent, that police officer has a duty under the law, but omitting to carry out that duty is a crime for a police officer, and in that regard a police officer can be charged because there is a duty or an act. If somebody kills another person, that is act of killing. So when we look at section 316, which is the section that deals, section 316 of the criminal code, for instance, which is the section that deals with murder, then we will see how murder is defined in that particular section. And we know that when somebody kills another person, then that act amounts to murder. This is the punishment for murder. Then that section 316, is the written law, and the punishment will be found in section 319 of the criminal code. That is the written law. So let me also, in Nigeria, no person can be charged with any offense unless it's defined in a written law. So this point has been made before, with definite punishment prescribed. This point has been made before. So no person can be charged with any offense. So these are the points that have been made before. These are the 3 points which I have highlighted above. Then something that is new here is such offense must not have been brought into being retrospectively. So what do we mean by this? Retrospectively in this is talking about, for instance, if something is not an offense today and it is done. Take for instance, there was this case of Chief Body George. He was charged for contract splitting at a time, and he was convicted by a trial court. But when he appealed against his conviction, he won. The appellate court set the conviction aside on the basis that when he committed that contract splitting, there was no public procurement act which rendered that act to be an offense. And when he did it in a year, let's take it for instance that he did contract splitting in 2016, and by 2017 the law was passed. So in 2017, when the law was passed, he was now charged to court for something that he had done before that act became a crime. So the law does not allow that. That is also not in line with section 36(8) of the Nigerian Constitution. It doesn't allow anybody to be punished for an act which is not a crime as at the time it is being committed. So, and that is why Body George was set free eventually on appeal in that case. So for anything that will be a crime, then it has to be not retrospectively. Then I give some examples of sections of law which deal with criminal acts or criminal omissions. This section 358 of the criminal code is talking about attempted rape, and it says any person who attempts to commit the offense of rape is guilty of a felony and is liable to imprisonment for 14 years with or without whipping. Any person who commits the offense, who attempts. So attempt is key in this definition. Attempt is key in the definition. Who attempts the offense of rape. So for us to understand fully what the offense of rape itself is, we have to check section 357 of the criminal code. So, but attempt it. You have done certain things showing that you want to commit rape. You have asked a lady to forcefully remove her clothes. You are already pushing her down, but you have not really succeeded by having penetration of a private part to commit the full offense, which is rape itself. But having done all those things that you have done is your attempt. An attempt in itself is a crime, and the crime is called a felony. If a crime can be called a felony, it can be called a misdemeanor, it can be called simple offense. A felony is any offense that carries not less than 3 years imprisonment. So it can be 25 years imprisonment, it can be life imprisonment, it can be death penalty. is all under felony, and those are serious crimes. Armed robbery is another example of felony. Robbery is another example of felony. Murder is an example of felony. Treason is an example of felony. Kidnapping is an example of felony. So of felonies, there are many. So this is an example of a law that has defined a particular offense, which is attempted rape in this particular section. Another example is section 327 of the Criminal Code, and it says any person who attempts, this one is also an attempt, to kill himself is guilty of a misdemeanor and is liable to imprisonment for 1 year. So the offense here is attempted suicide, attempting to kill oneself. When somebody is tying the rope, hanging himself, and unfortunately for the person, somebody comes in and rescues the person. So if that happens and it gets to the attention of the law enforcement agents, that means the person has attempted to kill himself. That is attempted suicide, and the law calls it misdemeanor. So misdemeanor is a crime, the punishment for which is not less than 6 months, but is not up to 3 years. It's not less than 6 months, but it's not up to 3 years. That is misdemeanor, and it is any offense that the law has called misdemeanor, and the punishment is not less than 6 months. For this one, the punishment is for 1 year. It's 1 year, 1 year imprisonment. So I've been able to give 2 examples in this, but I will move to the next slide and take one more example of. So this is another crime. So the point in this particular one, this one is talking the following persons: every common prostitute wandering in any public way and behaving riotously or indecently shall be deemed idle, disorderly persons, and may be arrested without warrant and shall be guilty of a simple offense. So I want to use this as an example of simple offense, because in terms of the punishment, this one is just the punishment for this offense is 1 month. So as I said before, I defined felony, I defined misdemeanor. Now, definition for simple offenses: any offense that is neither felony nor misdemeanor will be regarded as simple offense, more so that the law calls it simple offense. And also in terms of punishment, less than 6 months, like 5 months, 2 months, 3 months, or just payment of fine, maybe 1,000 naira, 500 naira, something like that. That one will be regarded as a simple offense, which is the simplest of the category of offense that anybody can commit. So I move to. So I still continue with what is criminal law. Now in this particular case, and this case is key, I've said before that for any act to amount to a crime, it has to be defined in a written law, and that's what played out in this Aoko versus Fagbemi. In this particular case, a woman was tried by a customary court for having committed, a married woman for having committed adultery, having sex with another man who was not her husband, and she was convicted of that crime of adultery. But she appealed to a high court, and the high court held that the offense for which she was convicted was not defined in a written law, that there was no any section of the criminal code that called adultery a crime and that prescribed a specific punishment for it. And it was on that basis that her conviction by a customary court was set aside by the high court. So, and this is also a constitutional provision matter, that for any crime to amount for any act or omission to amount to a crime, it has to be defined in a written law. So we have to be able to refer to the section. So whenever law enforcement agent says anybody commits a crime, then that means we must have in mind the existence of a section of law that defines that crime and that prescribes punishment for it. So once none like that exists, that means no crime has been committed, even if the conduct is condemnable or morally wrong. because being morally wrong is not always being a crime. So an act or omission that is morally wrong is not always a crime. As I gave an example the other time of a young person who omitted to greet an elderly person, or even a young person who abuses an elderly person, is morally condemnable, but it's not a crime. In essence, an act or omission does not constitute an offense unless it is stated as such in a written law and a definite penalty is prescribed. There are examples of crimes. There are so many examples, I can't exhaust examples of crimes, but I give some in this slide. Unlawful assembly is one. That one can be found in section 88(1) of the Criminal Code. Stealing, section 383(1) of the Criminal Code. Burglary, section 411 of the Criminal Code. Robbery, section 1 of the Robbery and Firearms Act. That is where robbery, armed robbery, section 1 of the Robbery and Firearms Act. Robbery and armed robbery, they are not the same, they are close. This is when violence is used to rob another person of his or her property. That is robbery if it is just threat of violence or the use of violence without the involvement of gun or any offensive weapon, any weapon or any object that can inflict injury on another person. But once the use of firearms, the use of any offensive weapon that can inflict injury on another person is involved, then we talk about armed robbery. Robbery is 21 years imprisonment. Armed robbery is death penalty. That is the point. Then examination malpractice is also an offense, and that one is taken care of by Examination Malpractice Act. It's a law passed by the National Assembly which criminalizes examination malpractice which may be committed by a candidate sitting for an exam, by an invigilator, by a school proprietress or school proprietor. So if such acts like cheating, like smuggling in papers during exam and things like that will constitute examination malpractice, and it's an offense. Courtesan is also an offense. In Lagos State, for instance, the punishment for courtesan under the Courtesan Prohibition Law 2021, courtesan carries 21 years imprisonment. Anybody who is a courtist is 21 years imprisonment. Kidnapping under section 364 of the Criminal Code, kidnapping carries 10 years imprisonment. But in Lagos State, under the law of Lagos State, under anti-kidnapping law of Lagos State, the punishment is 25 years in Lagos State. Rape under section 357 of the Criminal Code is life imprisonment if committed, and that is when a man has carnal knowledge of a woman who is not her husband without her consent. So if a man has sexual intercourse with a woman with her consent, even when the woman is not his wife, then there is no crime. That may be adultery, but adultery is not a crime under the Criminal Code. When I discuss Criminal Code and another code in subsequent presentation, then I will throw more light on that. So that is rape. Rape, as I said, life's imprisonment. We have cyber crimes. Under Cyber Crimes Prevention and Prohibition Act of 2015, there are different acts that constitute crimes under Cyber Crimes Act. We have stalking is a crime. We have credit card fraud is a crime. We have identity theft is a crime. We have different kinds of Yahoo is a crime. All these cyber-based fraud is a crime. Then murder is a crime, of course. Then let me quickly draw some differences between criminal law and civil law. So a law is either criminal law or civil law. It is either of the two. But we are talking about criminal law now. In my previous presentation, I've also I spoke about civil law. So in this one, I'm concentrating on criminal law, but I will have to draw some differences so that the picture will be clearer. So who are the parties to criminal law? We usually have the state. State is the one that will prosecute anybody who commits a crime. So we have states. We can call the state complainant. Whoever is being tried, we call the person defendant. It used to be accused person, but we don't call somebody who has committed a crime accused person again. We call the person defendant. It was the Administration of Criminal Justice Act that has changed that nomenclature from being called accused person to now being called defendant. But under civil law, it is individuals who will take themselves to court. State is not usually involved. State will not be the one. For instance, under criminal law, if somebody is raped, it is not the responsibility of the victim of rape to prosecute the perpetrator. It is the responsibility of the state. So it is the state's responsibility to prosecute whoever commits a crime, even when the crime is committed against individuals, against private citizens. But the state will take up the prosecution. Then individuals will take up their own responsibilities. Take for instance, if two persons are having conflict over ownership of land, so it is not the business of the state to sue another person or one of them to court. It is the responsibility of the individuals. If there is a breach of contract, it is the responsibility of the individual. If a tenant refuses to pay rent, it is the responsibility of the house owner to sue the tenant to court in order to recover rent or eject the tenant. Now, consequence of criminal law: whenever crime is committed, then punishment is the consequence. But that is after the person must have been tried by a competent court of law and found guilty. While in the respect of civil law, it is liability in terms of payment of damages. So if somebody has committed defamation against another person, it is the responsibility of the person who feels defamed to take the other person, the defendant, to court and claim for damages. The standard of proof in criminal law is proof beyond reasonable doubt. That is, meaning that every element of a crime must be proved to the satisfaction of the court. Every element of the charge of the offense must be proved to the satisfaction of the court. For instance, in a case of murder, there are things that have to be proved. It has to be proved that a person has been killed. It has to be proved that it is this person, it is the defendant who is responsible for the death of the deceased. Then it has to be proved that the defendant intentionally killed the deceased person. So all these elements have to be proved. If one is proved, the other is not proved, then the person will be set free. The case will be said not to have been proved to beyond reasonable doubt. Then balance of probabilities. That is the standard in respect of civil law. So balance of probabilities is just the court will just consider the evidence of the two parties before it and see which evidence of the two is more believable than the other. So whichever one that the court feels is more believable will be the winner of that case. Terminologies used in civil law and criminal law. Under criminal law, we have terminologies like guilty, sentence, we have not guilty as well, conviction, arrest, detention, bail, arraignment, prosecution, we have prima facie case, we have confessional statements, and so on. Under civil law, we have liable, win, or lose. So these are some of the words or terminologies we make use of in civil law. Then mode of commencement, we use charge or complaint information to file cases, criminal cases to court, depending on the court, whether it is magistrate court or it is high court. So in high court, we usually use complaints or information to file necessary papers that will show that this person has committed a particular offense. So it will just state like that you, Mr. So or Mrs. So did so act on so date at so place, and because of what you have done, you are liable, you are guilty of an offense under section 214 of the criminal code, and you are liable to specific of punishment. So it will be, or you are liable to punishment. So it will be stated in a charge that way. Writ of summons, these are documents that are used to file civil cases in court. I have explained this clearly in my presentation on civil procedure, and for better understanding, I advise that video should be watched in case somebody has not watched it.